Are you ready, Mr. Pretorius? Yes.
Thank you, Chair. To report back in relation to the recording, the engineers have tried their best to produce a better, more audible version without success. The fault lies with the recording itself. There are ways of enhancing recordings, but those must be done technically, and we will try to do so.
Okay.
Secondly, Chair, we have established that the date in paragraph 43.8, as originally placed in that paragraph, March 2015 is the date at least intended by the witness, Mr. Nxasana. But what we would like to do, following your advice, and have recast is Exhibit EE4, which is the timeline.
Yes.
And we have.
Or did you say in regard to 43.8, that's the date that he had intended?
Yes.
So, okay, so it wasn't an error in terms of what he intended to say.
2015 he
Yes.
intended to say, and he will
Yes.
tell us about that in due
Okay.
course in relation to the timeline.
Okay.
Mr. Nxasana, would you go to Exhibit EE4, which is after the EE4 divider in your file? Do you have that?
Yes, I have it.
That is a timeline recast by the legal team during the long adjournment, and we have attached relevant documentation from other sources. There are various sources for this timeline, and I'll refer to them in due course, including
Yes.
the affidavit of Hawthorne
Yes.
in the Corruption Watch matter.
Okay.
Or is it the Freedom Under Law matter? If you could go to the timeline at the point where it says item 1, do you see that?
Yes, I see that, Chair.
On the 4th of July, you were informed by the former president that he had taken a decision to institute an inquiry into your fitness to hold office.
That is
That's
correct.
been your evidence.
Yes, Chair.
On the 7th of July, you obtained an opinion from Advocate Ellis, SC, is that correct?
That is correct, yeah.
Right, that is on page 37 of your papers. The source of that information, that date, is the affidavit of Mr. Hofmeyr. It's referred to on page 37. Do you see that?
Yes, Chair.
Does that accord with your own memory?
That is correct, Chair.
And in that opinion, Mr. Ellis made certain recommendations, including a recommendation that Ms. Jiba be provisionally suspended, pending an inquiry into her fitness to hold office. The recommendation continued that a criminal investigation for perjury be opened against Ms. Jiba. And finally, the recommendation was that the findings against Ms. Jiba should be referred to the General Counsel of the Bar for their consideration.
That is correct, Chair.
Then on the 18th of July 2014, the memorandum signed by Mr. Hofmeyr was forwarded to Minister Masuta. That memorandum appears as an annexure to this timeline, Chair, at page 184.24. It's a memorandum dated 18 July 2014. from Mr. W.A. Hofmeyr, Acting
Can you find it,
National
Mr.
Director of
Nxasana?
Public Prosecutions,
Sorry.
addressed to Mr. Masuta.
I think he's still looking for the memorandum, I think.
Okay?
Page 184.24 at the top, MSON 184.24.
Are you at the timeline? Go to the timeline.
Yes, there is the timeline.
It's just a few pages on from the timeline.
Yeah, okay.
Yes, can you find it? Page 184. You know, you mustn't be confused with the bigger numbers where there is 588, which isn't bigger.
No, I've got the timeline. I'm betting to
Yes,
locate-
it's a memorandum on the letterhead of the NPA. That page is also marked 588 in bigger numbers than 184.24. Maybe somebody
I'm on
should go
it,
and
yeah.
assist him.
Yeah, I found it.
Oh,
I found
okay.
the
The
memorandum.
chair is suggesting that you ignore the bold type clear numbering and you look for the other numbering.
No,
I found it.
yeah, I found it.
Yeah, whenever there is any reference, whenever Mr. Pretorius refers to page numbers and whenever I do the same, we'll be using the MSON page numbers.
Oh, yes,
But
I
we
see.
won't keep on saying MSON, we'll just say 184 point whatever, or 184. Okay, so ignore the bigger page numbers.
Okay, okay.
Okay, all right.
Yes, I've got it.
Right. You have it. The origins of that memorandum, firstly, is that the memorandum forwarded by Mr. Hofmeyr to Minister Masuta on 18 July 2014?
That is correct, Chair.
If you go back to page 37, now we're back in the affidavit of William Andrew Hofmeyr, which starts at page 34.
Page 37, yes, I'm back at 37.
You've got that.
Yes,
Paragraph 16 reads, "It was on the basis of this opinion, that is the Ellis SC opinion, that the NDPP instructed his legal advisor, Mr. Gerard Nel, to draft the confidential ministerial memorandum dated 18 July 2014. You've testified to that.
that is correct, Chair.
The memorandum was approved by the NDPP, that's yourself,
That is correct.
shortly before he departed on leave for 2 days, subject to a few minor changes that he required. Since he regarded the matter as urgent, he requested me to sign the memorandum once the changes had been made, as I would be acting as NDPP during his absence. Correct?
That is correct,
And
Chair.
so that is how Mr. Hofmeyr came to sign this memorandum as acting NDPP, but on your instruction.
That is correct, Chair.
That memorandum and was it sent with your approval and on your instruction?
On my instruction, yes.
The memorandum on page 37, paragraph 17, made a number of conclusions and recommendations, namely that the NPA and the NDPP should report the adverse findings to the Minister and President, recommend that the President should consider to provisionally suspend Ms. Jiba and Mrs. Mrwebi and Ms. Mnyati pending an inquiry into their fitness to hold office. Over the page 38, refer the matter and findings to the courts to open criminal investigations for perjury against the above-mentioned members of the NPA, and 4, submit the findings of the courts against the 3 members of the NPA to the General Council of the Bar. So those were the recommendations made by your office, approved by you, instructed by you, to be forwarded to the Minister of Justice at the time, Minister Masuta.
That is correct, Chair.
So to go back to the timeline, on the 30th of July 2014, and I'm still on the first page of the timeline, you received a notice of intention to suspend from the former president. Do you see that?
That is.
You've
that is
testified
correct, yes.
to that. The references are there.
Yes, I see that.
On the 30th of July, item 5 over the page, Minister Masuta acknowledged receipt to Mr. Hofmeyr of his memorandum dated 18 July.
Yes, I recall that.
And then on the 31st of July 2014, Constitutional Court Justice Yaqub was appointed to chair a fact-finding inquiry into allegations of unethical conduct by senior members of the NPA.
Yes.
Correct?
Yes, it is correct.
Then on the 1st of August 2014, and we'll come to this in due course, you made representations in reply to the notice of intention to suspend.
That is correct, Chair.
I'm sorry, Mr. Pretorius,
Yes.
just to clear up something. I think earlier on before lunch, I may have understood your evidence to be to the effect that you had communicated with the minister, Minister Masuta, and with the president, or maybe only with the minister, with a view to him conveying that to the president, your concerns about the conduct of Ms. Jiba and Mr. Mrwebi, and that you had asked that the president should consider suspending them and initiating disciplinary processes, and that instead the president instituted the inquiry against you and started considering the possibility of suspending you. But when I look at these timelines, it appears that actually I may have misunderstood and you might have not understood my question. It appears that the president notified you of his decision to institute an inquiry, and your approach to the minister and to the president happened after and not before he initiated an inquiry. Is that, do you see what I'm talking about?
Yes, I see what you're talking about, Chair. Yes, I think, Chair, because of the lapse of time,
Yes,
but we have now verified, as the Chair had requested,
yes,
with the specific dates.
yes,
But
yes.
in a nutshell, I think the conspectus of my evidence was that when I approached the president to institute disciplinary steps against these individuals, what happened was the other way around. He instituted the commission of inquiry against myself.
Yes, but the point I'm trying to make, and I just want to make sure that we understand each other, is that whereas that was my understanding of what may have happened, it's clear from this timeline that on the 4th of July 2014, that's item 1,
Yes.
we say the former President Zuma informed you that he had taken a decision to institute an inquiry in terms of Section 12(6) of the Npa Act.
That is correct.
Okay? And 7 July, there is the Ellis opinion.
Yes.
So I don't know whether the Ellis opinion had been requested prior to the 4th of July, but this is when it seems to either have been received by yourself or has been signed by council 7 July, after you had been informed that the president had decided to constitute an inquiry against you.
Yes. I think I think the opinion was signed on the 7th of July.
Of July,
by
yes,
the-
yes. Did you recall when you had requested it? Was it prior to 4th July or was it after? Is that something you can recall or not really?
I cannot recall.
You can't recall, okay.
Offhand, yes.
So, and then the appointment of Justice Yakub happens much later, end of July, and so on. So what I'm saying is the impression I get now, when I look at this timeline, is different from the impression I had before lunch. The impression I had before lunch was that you had already approached the president asking him to take action or consider taking action against Ms. Jiba and Mr. Mrwebi.
Yes.
And while you were waiting for him to actually do that, what you got was that the president decided to take action against you, as it were, in terms of by way of an inquiry and considering suspending you. But I'm saying that it does appear that the president's decision to institute an inquiry came first before you asked him to take action against
That
Ms.
is
Jiba.
correct, yes.
Is that correct?
That is the position, yes.
Okay. No, I thought it's important to clear
Yes.
it up.
I think what was happening before this, there were these communications by way of letters where the president called upon me to respond by a particular date
Yes.
about the media
Yes.
and the allegations of these
Security clearance.
security clearance and the criminal cases and the convictions. Yes.
Yes, okay, thank you.
To place that in its proper context and perhaps to allow the chair to consider the full context, before the 4th of July, had you any contemplation about taking action or initiating action against Mrs. Jiba and others?
Chair, before then, I would have contemplated getting a legal opinion and also appointing the fact-finding committee headed by Justice Yakub.
Okay. In that regard, what would you say to the suggestion that your decision to initiate action against Mrs. Jiba Mrwebi and Ms. Nyati was motivated and prompted by the receipt of the notice by you from the President of the 4th of July to institute an inquiry into your fitness to hold office?
That was not the position, because that was a decision that was taken after a special EXCO meeting arising from what was happening, especially the matter involving the criticisms of these advocates. I came to learn about it in the media, and we were very much concerned. I remember that we had a special EXCO to deal with these issues, and as EXCO, we took a decision that this is the way to deal with these issues.
We haven't learnt of that EXCO meeting. Do you know more or less when that would have taken place? We can get a minute of that.
You
Chair.
can get a minute of that. Yeah.
Just make a note.
Well, I think it may be important to have sight of when the brief was sent to council for an opinion on whether the criticisms of Ms. Jiba and Mr. Mrwebi in various judgments warranted disciplinary action, partly for the point that Mr. Pretorius is mentioning, because it may be, we don't know, it may be that the position may be taken that when you realize that the president was contemplating or had decided to constitute an inquiry against you, your response was then to effectively say, well, I can't be the only one to be dealt with. Let me ask him to also deal with Ms. Jiba and Mr. Mrwebi. There may be nothing wrong with that, but it might be different from a situation such as the one I thought was the case before lunch, where you say to the president and to the minister, here is evidence of what I believe is misconduct by Ms. Jiba and Mr. Mrwebi. Take action. And then no action is being taken against them. Instead, action is being taken against you. So that's what we need to look at, to understand. But I think you may, even after today, need to refresh your memory on everything, so that later on, if there is anything you might wish to clear up in your evidence, which you might have said, because without the benefit of refreshing your memory on other things, then you can clear up. Okay,
I understand.
is that all right?
Yes.
Okay, thank you.
Yes, the only comment in relation to that we now know is that the opinion was received on the 7th
Of July,
of July.
yes.
And
No, he said it was signed on the 7th. I
of
don't know.
July.
I found something here, Chair.
Yes,
That is on page 184.27.
184.27. Yes.
In paragraph 12.
Oh, yes. You want to read that?
Yes. On 26 June 2014, the National Prosecuting Authority briefed Advocate Patrick Ellis, SC, to furnish a legal opinion on the following questions. A, the disciplinary procedures available in respect of senior personnel at NPA. B, whether disciplinary steps ought to be taken against Advocates Jiba, Mrwebi, Mzinyathi, and Moiponi, primarily as a result of the findings made in the judgments referred to in paragraph 10 above, and the judgment of Govan J. in Boysen versus Acting National Director of Public Prosecutions and others.
Yes, at least that seems to indicate that at least asking for briefing counsel for an opinion happened before you were informed of the President's decision to institute an inquiry.
That is correct, Chair.
Okay.
Thank you for that, Mr. Nxasana. I was going to comment on the improbability of senior counsel furnishing an opinion in 3 days, but I thought the better of it.
Well, the one thing which I want to ask arising out of this is whether you are able to say, Mr. Nxasana, who other than yourself and the state attorney involved in the matter and counsel who else may have known that you had sought counsel's opinion on this matter? Would there have been anybody else that knew before the 4th of July?
Yes, because the request went under the hand of the CEO then, Mrs. Advocate Karen van Rensburg was the CEO of the NPA.
Yes. That would be the only other person, or was the matter handled in such a way that a lot of other people may have been aware?
And Advocate Mr. Hofmeyer also was aware. Advocate Gerard Nel was also aware.
As far as you know, Ms. Jiba and Mr. Mrwebi didn't know before the 4th of July.
I won't.
You wouldn't know. You have no basis to.
Yes.
Okay, all right. But at that stage, your communications with the minister or the president, would they have included you saying anything along the lines that you were contemplating seeking an opinion about disciplinary action against them, or not really?
Chair, I also stand to be corrected. I cannot remember, but I want to believe that the meetings that I subsequently held with the president, those meetings took place before July or June. I think it was around May, if I'm not mistaken. And I want to believe that during our interaction, I had informally told him, not in writing, that he has been misled. And in fact, it is the very people who are driving this agenda. Before I even sent the memo that I asked Gerard Nel to send it to him.
Yes, but my question was specifically about whether the president may have known from being told by you before 4 July 2014 that you could be wanting to have this action taken against Ms. Jiba and Mr. Mrwebi.
That is what I'm saying, Chair. That is what he could have known during our interaction.
Yeah, but how would he have known? Did you say so specifically to him? How would he have known that is what you were contemplating?
Chair, although I cannot recall now, but I want to believe that, I have reason to believe that I must have communicated that to him during our engagement.
Okay, okay, thank you.
If we could go back to item 5, on the 30th of July 2014, it appears that Minister Masuta told Mr. Hofmeyr that he had received Mr. Hofmeyr's signed memorandum of 18 July 2014. That's apparent from the documentation. We haven't got a reference there yet. But that's item 5 in the timeline. Item 6 reads, item 6, according to your own affidavit.
I'm sorry, Mr. Pretorius, I think I've lost the page for the timeline now.
Okay, it's behind divider EE4.
Oh, okay, thank you. I've
Page
got
2.
it. Okay, I've got it.
If we could go to item 6, on the 31st of July, Justice Yaqub was appointed to chair a fact-finding inquiry, according to your affidavit.
That is correct.
Then item 7, on the 1st of August 2014, it's apparent that you made representations in reply to the notice contemplating your suspension.
That is correct, Chair.
Then on the 8th of August, former President Zuma wrote to you to justify his refusal to provide particulars of the allegations against you.
That is correct.
And on the 8th of August, in addition, Minister Masuta, my apologies, acknowledged receipt of the 18th of July 2014 Hofmeyr memorandum in correspondence with you.
Yes.
In other words, he'd already acknowledged receipt to Mr. Hofmeyr himself on the 30th of July, but in correspondence with you on the 8th of August.
On the 8th of August, that is correct.
He said he had received it.
Yes.
Then on the 8th of August, item 10, you submitted a founding affidavit in an application in the High Court to compel the former president to provide you with further particulars pursuant to his intention to hold an inquiry.
That is correct.
You deal with this in your affidavit. Then on the 11th of August 2014, you replied to Minister Masuta. Now, we should perhaps deal with that. 18451.3. Can you find that for me? Yes. Chair, I hesitate to make reference to the big bold numbers, but there's a yellow
Yes, I've got
or
it.
an orange marker in the documents following the timeline, headed letters. No, it's an EE4. Just before EE5, you'll see an orange sticker. Is there no orange sticker in your file? Oh dear. Let's deal
Have
with
you
it in
got an
another way.
orange sticker on your file, Mr. Nxasana?
I'm not sure which one is orange.
The first one with letters written on it.
Sorry?
Just go back.
I found the letter that you are referring me to.
Have you?
Yes.
18451.4.
Yes, with the bolded number 618.
Yes.
What is the page number? 184?
51.1. It's not in any sequence, Chair, because there are other documents intervening. But if one goes to the 184 numbers,
I've got 184.51.1 without a yellow sticker.
yes, that's the one. That is a letter addressed to you by Minister Masuta. Do you see that?
Yes, I see that one.
And the letter is signed by the minister on 8 August 2014.
Do you see that?
Yes, I see.
Now, in that letter, Minister Masuta says to you, as I read it, I acknowledge receipt of your memorandum, or the memorandum of 18 July 2014, making certain recommendations to the President.
Yes.
Mr. Pretorius, when we have difficulty locating these documents, better to read what is there, otherwise the one who looks for it later on will think it's a wrong one. My one says something like, I am or I are in receipt of a memorandum. That's the first sentence. Is
Yes.
it? Are we looking at this?
We're looking at the
It's
same
just
one.
that you said I acknowledge, and I didn't see acknowledge. I began to think, well, later on somebody will say, I'm looking at a wrong letter. It does
Yes,
say,
but
it doesn't
perhaps
say
the
acknowledge.
description in the timeline is incorrect. But in that letter, dated the 8th of August, 2014, Minister Masuta says that he has received the memorandum signed by Mr. Willie Hofmeyr.
That is correct.
And he notes that that memorandum recommends that he, that is the minister, approach the President with the recommendation or request to suspend Advocates Jiba, Mrwebi and Zinyati.
That is correct.
But he says to that, before he does that, he wants certain information from you.
That is so.
And you reply to that letter at 18451.3 to say, we haven't had an opportunity to meet, let's meet.
That is correct.
Correct? And then over the page, and on the 12th of August, the Minister says on page 18451.4, I note that you want to meet, but give me the information anyway.
That is so.
So that exchange of correspondence takes place between the 8th and the 12th of August 2014.
That is correct, Chair.
Then on the 17th of September 2014, you submit a memorandum to Minister Masuta.
Yes, responding to what he had raised in his letter dated the 8th of August 2014.
That memorandum is at 184.1.
One.
Sure.
There's something wrong with that number, isn't it? Earlier, we had 184.49 and so on. And then much later, we have 184.1. Mr. Pretorius?
These were all paginated and numbered in the break, Chair, but 184.1 is in fact towards the end of the bundle in EE4. It should have been marked with a, perhaps,
Well, yeah, if we don't correct it now, then in the transcript, if we refer it to, could cause confusion.
yes. It is number 184.1. Page 184.1, but it's out of sequence and we can easily put it back in sequence
But in the meantime, how will you refer to it?
by its page number. By its page number, which is indelibly marked on the page.
184.1?
Yes, Chair.
I think that is what would cause confusion. Or you mean that you would take it back to the right place later?
Yes, Chair.
Would that work?
Yes.
I'm just trying to look whether,
It should, because anyone reading this bundle will go
Yes.
to 184.1.
so it was just located in a wrong part
Yes.
of the bundle.
Yes.
Okay.
Well, I'm sure the person who did it will say it's correct, but
Yeah, no. Well, if that will work, that's fine, because then referring it to it as page 1841 would be fine. Okay, all right. Let's call it. Looks like that should be fine.
yes. I had hoped that the stickers would appear there, but for some reason they didn't.
Yeah.
Anyway, do you have 184.1?
That is correct, Chair.
Do you have it, Chair? It's
Yes, I
immediately after this correspondence that we've just referred to.
I know. I found it a long time ago.
Good, thank you, Chair.
Yeah, it was just the page numbers that we would use that I was concerned whether it wouldn't cause more confusion using them.
No, I understand, Chair.
I think if it's just the
You're
fact
clearly
that
more
it's
skilled and
located.
experienced at finding page numbers
Yeah.
than our witnesses and
Yeah.
myself.
Okay, all right. Let's continue.
184.1, you got it.
I've got it, Chair.
That's the memorandum that you've just referred to, dated 17 September 2014. If we could just deal with it briefly, how did it come about that you then sent this memorandum to Minister Masuta?
That was because after Mr. Hofmeyer's, after the memorandum that was signed off by Mr. Hofmeyer was delivered to the minister. The minister in his response dated the 8th of August 2014, raised some issues. Then I wrote back to him on the 11th of August and said to him, I think it will be better for us to meet and discuss a lot of issues pertaining to NPA, because the minister had been appointed for a period of 2 months. He was in office for 2 months without we had not met by then. But the minister then insisted, I think, that in principle he understand that we have to meet, but he nevertheless felt that I must respond. Hence, I then responded by way of that memorandum dated the 17th of September.
All right, and you then sent this memorandum?
Yes. And in that memorandum, I basically reiterated the contents of the memorandum that was sent off by Mr. Hoffman.
All right. Okay, if we can continue with the timeline for the moment, we're going to come back to one or two of these issues in due course. On the 3rd of November 2014, against item number 14, you then, through your attorneys, informed Mr. Hulley of your agreement to a mediation process.
That is correct.
Now, generally and as a matter of principle, how do you understand mediation? Does it involve any concession on the part of or admission on the part of a person entering into a mediation process?
Concession.
Well, when you agreed to a mediation process, did you intend to concede anything?
No.
What was the purpose of the mediation process?
If my memory serves me well, I think there was a suggestion from, I think it was from the presidency. I cannot remember whether it was from Bonsiwe Maken, one of the legal advisors, after we'd had those meetings, that they suggested that there should be a mediation. But I think in the tone of their letter suggested that the mediation should be confidential. And we responded by saying, I agree in principle that a mediation should, to avail myself for mediation, but that it should not be confidential because I do not understand.
The point is a somewhat different one. The issue, which we will come to in a moment, is whether you required or requested that you be allowed to vacate your office.
No, I did not make that request.
I'm not saying that you did. I'm saying that's an issue that we will look at in a moment.
Okay.
It's an issue of some controversy.
Yes.
By agreeing to settle the dispute between yourself and whomever else, even on monetary terms, can it not be implied that you were in fact requesting to leave?
Not at all.
Why not?
Because I made it clear, I think you will see in the correspondence, also the exchange of correspondence, and in our meetings, I made it very clear because there was this attitude that I must leave office, and I remain steadfast, saying that there is no reason for me to leave office because I still consider myself fit and proper to hold office. And during the exchange of the correspondence between my attorneys and the presidency, I made it very clear, we made it very clear that we have never, one, initiated the discussions, two, even the the discussions around the settlement of whatever issue that was there. And there was no way, we maintained that there is no basis in law and in fact for me to relinquish my position as the National Director of Public Prosecution. But then, with the rider that if they want a so, and I made it clear in that letter, I think the letter dated the 10th of December 2014, we made it clear that unless then I am paid the remainder of my contract, then I'll relinquish the position as the president would want me to vacate my office.
Let's go back to the mediation.
Yes.
Who came up with the idea of mediation?
It was I would say the presidency. I think the legal advisors.
It was the presidency.
Yes.
And you think it was the
Yeah.
president's legal advisor?
Yes, in one of the correspondence. Yeah.
Yes. And you made reference to Miss
Bonisiwe
Bonisiwe Mokene. She was she a legal advisor in the presidency?
That is correct, Chair.
And then, of course, we know you did refer earlier on to Mr. Hali. Was he also legal advisor to the
He was
president?
also legal advisor to the president.
Yes, but as between the two legal advisors and maybe any others that they may have been there, are you clear as to which one came up with the idea of mediation, or are you not sure?
The letters
Or was it in a letter?
it was in a letter.
Oh,
Because we responded in a letter. We
Yes.
responded and referred to specifically the letter that he had sent to
Yes.
my attorneys.
Okay, all right. So that letter, I'm sure, will be found.
If you would go to page 185 in EE4, that is again towards the end of that bundle, page 185. You will see the letter of 3 November 2014 there.
Yes, Chair.
Do you have it, Chair?
I have it with me.
It reads, "We refer to the telephonic conversation between the writer hereof and yourself on the 30th of October 2014, and the writer is Mr. Mabunda of your attorneys, correct?
That is correct.
We
it's
confirm that you have
addressed to
raised
Mr.
concerns about the ordinate time the matter is taking, and that in your view the delay is attributable to our client."
Yes, and the letter is addressed to Mr.
To Mr. Hali.
Yes, and
Yes.
Mr. Halley is there acting on behalf of the President. I think we know that.
Yes, Chair.
President at the time. Mr. Mabunda says he was out of the country. He says further, "We have, however, urgently and subsequent to our telephonic conversation, consulted with client who has instructed us to respond as follows." It appears that this letter was written in response to issues raised in a telephone conversation of the 30th of October 2014. Correct?
Oh, yes, I see that, yeah.
And the response is as follows: our client is willing to participate in the mediation process as your client has proposed. Is that a correct summation of events?
Yes.
It states here that
Well, Mr. Pretorius, you want him to confirm whether it was Mr. Hali's client who had proposed the mediation, because you haven't finished this summation. You wanted him to confirm whether that's the correct summation.
All right, perhaps let me go through all four first. Point 2, although client would have preferred to have the matter resolved by way of inquiry, he is of the view that it is in the best interest of the NPA to have the matter finalized expeditiously by exploring the mediation route. Point 3, it should be put on record that our client does not in any way waive any rights he has in law by agreeing to explore the mediation process. And as such, the proposals of the mediator shall not be binding on him unless expressly agreed to in writing. And then the letter continues on over the page with a request to initiate the mediation process. Now, the chair asked you directly whether the mediation idea or proposal emanated from you or from the side of the president or the president's advisors. And you responded as you did, but does this assist you?
Yes, it does, because it says that in paragraph 1 that I was willing to participate in the mediation process as proposed by the president.
Independently of this letter, do you recall where the proposal came from?
Yes, because I never proposed any mediation.
So you say it could only have come from the side of the,
Of the president, yes.
presidency?
Yes.
Okay.
In fact, the letter is very clear that I would have loved to have the matter resolved by way of an inquiry.
Yes. Is that later in the letter?
It is on paragraph 2 of the letter, on the first page. Although client would have preferred to have the matter resolved by way of an inquiry, he is of the view that it is in the best interest of the NPA to have the matter finalized
Oh, yes.
expeditiously by exploring the mediation route.
So is that a suggestion that your first prize
Yes,
was that let's go to the inquiry,
yes,
but because
they had proposed.
they proposed
the-
mediation,
Yes,
you were willing to participate in it?
as long as
Yeah.
the process would be expeditious.
Yeah, okay.
The next letter, which is an important letter apparently in the sequence of events, is against item 9 on the next page of the chronology, and it appears at page 187, immediately after the letter of the 3rd of November, and that's the letter of 10 December 2014, and it's addressed by your attorney, Mr. Mabunda, to Boniswe Mokene. Who is that? Bonisiwe Mokene.
Yes,
Is that the person you referred to earlier?
yes, as the legal advisor to President Zuma at the time.
Right. And it says, we refer to the above matter and particularly to the meeting we held on the 8th instant, that would have been the 8th of December, at the residence of the
Mahlambandlovu.
President.
Matlambandlov.
Yes. Wherein it was discussed, advised, and agreed as follows. Now, before we go there, were you at that meeting?
Yes, I was at that meeting.
What happened at that meeting, briefly? Well, firstly, who attended?
At the meeting was the president, myself, Mr. Mabunda, and the professional assistant was the attorney, Miss Shelley Netam. I have the surname.
Yes.
Netandani, something like that, yeah, at that meeting.
Whose attorney was that?
She worked in the office of Mr. Mabunda and she was involved in this matter. Yeah.
Mr.
was-
Mabunda himself was not there?
Mr. Mabunda and herself.
Oh, the two of
They were
them
both-
were
the two
there.
of them were there.
Okay.
Now, this
And
meeting,
what was discussed? I think that was the question briefly. What was discussed at this meeting?
Chair, it was the same issue about the inquiry or not the inquiry, the same issue that if I put my foot down that if they want me to leave, because I still believe that it was not necessary, there was no reason for me to leave, they must be prepared to pay me for the remainder of my contract, of my period, which was 10 years. And then we started making some calculations, and at that meeting I was then asked to provide Bonsiwe my leave.
That's Ms. Mukene.
That's Ms. Mukene, yes. I was asked to provide, we were asked to provide them with my leave days and also, I think my tax, something like that, my tax details and my salary details.
this discussion that took place and the settlement proposal, from whom did the settlement proposal come? This meeting was taking place at the residence of the former president.
Chair, I remember that by settlement proposal, I'm referring to the figures or that we settle, if I may just get clarity.
Yes, I think maybe Mr. Pretorius, you might wish to, I think you are talking about the fact that subsequently there was a settlement proposal made.
Well, I'll tell you why I asked the question.
Yes.
Because it's apparent from the contents of this letter that a settlement proposal was made to you based on certain legislative provisions
Yes.
in the Npa Act.
Yes.
In other words, it was made to you, well, you tell the chair. What was the basis of the settlement proposal made to you?
Chair, the
Let me be fair to you. Read the letter first, and then answer the question for the benefit of the chair, please. Because it goes to certain allegations that I still need to put to you, emanating from the President himself.
Is that the same letter of the 10th?
The letter of 10th of December.
Yes, thanks.
All right, you read the letter.
I'm sorry, Mr. Pretorius. Before Mr. Pretorius asks you a question based on that letter, let's go back to the meeting of the 8th of December. And this letter seeks to confirm some things emanating from that meeting.
Yes, Chair.
Okay. Who had come up with the idea that there should be a meeting held on the 8th? Or who came up with the idea of that meeting? Do you remember, or is that something you can't remember?
I think the idea of a meeting would have come up with I think it was communication between Mr. Mabunda, my attorney, and Mr. Hali.
Okay, it may have been through discussions among them.
Discussions, yes.
Yes, okay. What was the purpose of that meeting as you understood it? Why was that meeting called as you understand the position?
Chair, my understanding was that we're still going to discuss the issue of whether or not, because we're trying to persuade the President. That is our view. We're trying to persuade him that there is no need for him to hold the inquiry in the first place, and there was no need for me to vacate the office of the NDPP. Whilst on the other hand, it was clear from the meeting that they had already made up their mind that they wanted me to leave.
Now, excuse me, that I was about to ask the question. Prior to this meeting, had anybody from the presidency, either the president himself or those who were acting on his behalf, had they said, or anybody said, they wanted you to leave your position of NDPP, either in a letter or in discussions? In other words, I'm trying to see what was to the extent that these may have been negotiations aimed at resolving something or some dispute, what was the dispute that was sought to be resolved?
Chair,
if there was a dispute.
Chair, except to say, according to my recollection, whenever I spoke to President Zuma, we would speak and I would convince him, I would put my side of the story to him informally, and I would persuade him, I would tell him that he was misled. But at the end of the day, he would seem to be getting to understanding me, but then at the end would then say something about Nomgcobo Jiba, I think, but I think we must just settle this. you have to leave and you have to sort out your issues, the issues with my legal team of how you vacate the office.
Did that ever come from him?
That is correct, Chair.
And are you sure about that?
I'm sure about it.
That he said he wanted you to leave?
Yes, Chair.
And how, in terms of the time frame, are you able to indicate round about when he may have said that for the first time to you?
Chair, although I cannot remember the...
Was it still 2014 or was it in 2015? Was it around mid? Was it after? Was it after he had notified you that there was going to be an inquiry, or was it even before?
Even before, Chair, because in our engagements, before he even sent that letter dated July 2014, where he indicated that he intended establishing a commission of inquiry, I was under the impression that he had changed his mind. He was no longer going to institute because of the interactions that we had together. Then it came as a surprise when he then somersaulted and changed his mind and sent me that letter that he intended to establish the commission of inquiry. And then when we engaged, and there was these engagements with my attorneys and Mr. Hali and Bonsil and himself, I think we tried even in those meetings to persuade them that there was nothing really that warranted me to leave the office. And we pointed out that even at the inquiry, the inquiry will not even find that I was not fit and proper to continue holding office. But then I think the decision must have been taken, because at the end we would talk and talk, but at the end then he will say, but I think you have to step aside, and you must then formalize the issue of how you are getting paid, and you will meet with my legal team to discuss that.
So are you saying that discussions, or either discussions in plural or the discussion singular, where the former president said that, happened before you received the letter saying there was going to be an inquiry into your fitness to hold office?
Yes, in some of the discussions before that, and even after that, Chair. Even after the letter.
Yes.
Yes.
So where he said you need to leave.
Yes, Chair.
And what was your response?
Chair, I remain steadfast, and I always told him that there was no reason for me to leave. And I told him that I kept on repeating myself that this was a campaign against me by these individuals, and they misled him, and there was no reason for me to leave. And even at the inquiry, I told the president that even the inquiry that he had constituted, I told him that that inquiry won't find anything against me, that
Yes.
it was not going to find that I'm not fit and proper to continue holding the office. And there were negotiations also. We would meet even after he had issued these letters. We also met. I remember we met again. I say, we met at Mahlambahlov. That was after the 4th of July.
You see, the one scenario is that the discussions could have been, at least at a certain stage, been about whether or not you were fit to hold office in order for the president to decide whether there was a need for an inquiry. That's the one scenario. Another scenario, and that in terms of that scenario, the president could have adopted the attitude that I don't know what the outcome of the inquiry will be if the inquiry is held. But if you want to persuade me that you are fit and to hold office and there's no need for inquiry, I'm happy to listen, and if you persuade me, I will terminate the inquiry. That's one scenario. Another scenario may have been that he may have been saying, I believe you are not fit, and I believe that the inquiry will find that you are not fit to hold office, in which case you will have to go. Rather than us reaching that point, why don't we find another way? That maybe that's another one. Maybe there's a third one, which may have been, I want you to leave, but let's rather agree on the basis on which you will leave. So are you able to say categorically which one of those fitted into his situation?
Chair, what I'm certain of during our discussions with President Zuma, it became clear to him that the information which he considered to me, that the information that he was given about me, he was misled. But I don't know why he then decided, because I don't know who he was talking to and who are these people that were pressurizing him and to what extent he was being pressurized. I don't know, because I got the impression that he was getting pressure somewhere to get me out of my office. Because when we spoke, ultimately considered that he was misled. And the issue of my fitness or otherwise, it didn't feature. All that he was trying in a nutshell, just to summarize, although I cannot recall the details of the meetings on various dates, but the conspectus of the meetings was to try and persuade me to resign, which I remained steadfast and refused to do it. And I said, because they are so content on seeing me out of the Npa, then they must be prepared to pay me. That was the basis of those meetings.
So did you say that he considered that he had been misled about whether you were fit or not fit to hold office, or in terms of the things that may have made him decide on the inquiry?
That is my view, Chair, because he considered, because one of the things when he said, you know, the things that these people were telling him, one of the things that people were telling him that I meet Mr. Nxoga, for instance, which he considered, I told him that was a blue lie. The other thing is, the one that I referred to earlier on before tea break, that after I had met with him at King's House in Durban, I think some people picked up, or the information leaked, that we're now talking, because initially, he was reluctant to even meet with me, he didn't want to meet with me. I think these people, when they found out that we are now talking, they were not happy, such that they tried to block our meeting, the meeting that I had without my attorneys with him at Mahlamandlovu. At one stage. That is where I had even said to the person who said the president was scared that I might be recording him. Then I said, no, I would come there naked if it means be. All of those things, they convinced me that he had considered that he was misled by being given all the information, the wrong information about me, and that he should not have taken this decision. But I don't understand, I don't know, for some strange reasons, that is my view, there was some pressure somewhere that he has to take this decision.
Yes. Okay, thank you, Mr. Pretorius.
The legal basis of the settlement proposal that was made to you on the 8th of December 2014, did you understand what that was?
Chair, I understood what it was. It was based on the fact that because they wanted me to resign, they were talking that I should leave. Then I had said, I'll only leave if I am paid the full amount of my contract. And then the settlement, that proposal that was made by Ms. Mahene, she then referred to the prescripts of the Public Service Act and the Npa Act and calculated it according to those prescripts. Then we disagreed there. Because our view and my view was that if I was leaving, I was not leaving NPA in terms of Section 12, subsection 8 of the Npa Act. That was our argument. The argument was that...
Was that your consistent view throughout?
That was my consistent view throughout, because in terms of that provision, the NDPP makes a request to the president. Then we are saying, and remember there was litigation that I had initiated against the president. Based on the litigation, for me not to continue with the litigation, and now we say we are settling, and I'm not leaving in terms of Section 12, subsection 8. You want me to leave, then you must be prepared to pay. It's a breach of contract, it's constructive dismissal, in other words.
Right. Can I just take this opportunity to read onto the record the provisions of Section 12.8 of the Npa Act? It reads, the President may allow the National Director or a Deputy National Director at his or her request to vacate his or her office, Roman 1, on account of continued ill health, or Roman 2, for any other reason which the President deems sufficient. Subsection B reads, the request in terms of paragraph A2 shall be addressed to the President at least 6 calendar months prior to the date on which he or she wishes to vacate his or her office, unless the President grants a shorter period in a specific case. Arising out of the provisions of that section, did you ever request or intend to request of the President to permit you to vacate office?
No, Chair, I never.
And is it your understanding that the settlement proposal made to you was made on the basis of that section, that it would be then taken that you had requested your termination?
Yes, Chair.
All right. Then you deal with that in...
I'm sorry. Can you just repeat, Mr. Pretorius, the question? I want to understand the answer correctly. I think I may have missed something.
Did you understand that the settlement proposal made to you was, let me put it slightly differently, intended to be an implementation of the provisions of Section 12.8?
That is correct.
In other words, you are requesting your termination, asking the President to allow your termination in terms of that section.
That is correct, sir, Chair, and that is why we rejected it.
Right. And
No,
your rejection is
that's
explained in the letter.
That's
we're
what
going
I
to
don't
come to.
understand. Mr. Pretorius has just read to you Section 12.8.
Yes, Chair.
And it contemplates that the NDPP may request the president to permit him or her to leave office. You understand that?
That is so, Chair.
Now, Mr. Pretorius asked you earlier on, did you ever request the president to permit you to leave office as NDPP, and understood you to say, no, you never made such a request? Did I understand you correctly?
That is correct, Chair.
Now, my understanding of this last question that Mr. Pretorius put to you, and he's going to tell me if I misunderstood it, and you are going to tell me if you had the same a different understanding. My understanding of what he put to you is whether your understanding was that the settlement agreement was an implementation, or the settlement proposal was as an implementation of Section 12(8), and understood you to say, yes, that's correct.
Chair, I understood Mr. Pretorius to be saying, his last question was that the proposed settlement, I understood the proposed settlement to be in terms of Section 12, subsection 8. Then
Yes.
I said, yes, that is how I understood.
The
That is why-
the proposal.
Yeah, the proposed, that's the,
Yes.
that's the word. That is why we rejected it, because we
Yes.
are of the view that I had not made a request to leave NPA.
Okay, no, maybe I then missed on. Maybe it's when we go to the documents that I would understand.
Yes, we'll come to the
yeah.
document in a
Yeah.
moment. This
Okay.
is just by way of introduction to what is made very clear in the letter. My question was intended to focus on the intention of the proposal rather than the intention of any subsequent agreement. And I think Mr. Nxasana understood it that
yeah.
way.
Okay,
What did you understand the intention behind the proposal made to you to be?
yes,
So
Okay.
perhaps that's a bit clearer.
okay.
Let's go to paragraph 2 then on page 187. This is your attorney's statement to the presidency in regard to the proposal made to you.
Yes. Yes.
It states, following our discussions of the 8th instance and the subsequent instructions from client regarding the proposed settlement, we would like to place the following on record. 2.1, we are of the firm view that the prescripts which you sought to rely on pertaining to settlement are not applicable in the present case for the following reasons. Was that letter sent with your knowledge? I think you say elsewhere that in your statement that you helped draft this letter.
Yes, Chair. That is why I know these provisions, because I was involved in drafting this letter.
2.1.1, the provisions of the Npa Act, which you seek to rely on, deal with a scenario where the NDPP is removed from office in terms of Section 12(6)(a). The procedure thereof is succinctly spelt out in Section 12, subsections 6, 7, 8, and 9 of the Npa Act. Then continues to read, we would consequently like to draw the following to your attention. 3.1, that it has never been the NDPP's intention to resign from his position since he considers himself to be a fit and proper person to hold this position. That is what is stated. Was that your view at the time?
That was my view at the time.
4, the proposed settlement was triggered by the discussions which the NDPP had with the President following the latter's announcement of his decision to hold an inquiry into the NDPP's fitness to hold office and the possible suspension pending the inquiry. 5, our instructions further are that the meeting between the NDPP and the President only took place after numerous attempts by the NDPP to seek audience with the President without success. The allegations in those 2 paragraphs, are they correct?
That is correct, Chair.
Paragraph 6, it must be remembered that the only time the President agreed to meet the NDPP was after the latter had lodged a court application inter alia interdicting the President from suspending the NDPP before the President provided further and sufficient particularity to enable the NDPP to respond or to show cause why he should not be suspended. Is that a correct allegation in fact?
It is a correct allegation.
Paragraph 7, we are advised that during the discussions the NDPP had with the President, the NDPP made it very clear that he will only consider stepping down from office if he is fully compensated for the remainder of his entire contract as head of the National Prosecuting Authority. You did make that clear, you've said already.
That is so, Chair.
It may be a fine legal point, but your statement to the President saying, yes, I will step down, will vacate office, will voluntarily leave office if you pay me for the rest of my contract, is that not akin to a resignation in terms of Section 12.8?
No, it is not.
Why do you say that? And I understand there may be legal argument about this, and I'm sure the Constitutional Court judgment considered that.
I'm sure that will, if you continue reading the letter, paragraph 10, there'll be the answer to your question, Chair.
All right, let's go then to 8 and 9. You say in paragraph 8, we reiterate, or your attorney says in paragraph 8, we reiterate that there's no factual or legal basis for our client to step down from his position. Paragraph 9, it is our considered view in the light of the above that the provisions of the Npa Act, read with the provisions of the Public Service Act, which you have alluded to, do not apply to this proposed settlement. And then paragraph 10, to which you've now referred, in the circumstances, our client will only consider the option of leaving office as the President would want him to if he is fully compensated for the remainder of his contract. Now that is what was said, and it was your view that the provisions of the Npa Act, particularly the one which we've just read, didn't apply to this
That was my view.
process.
That was my view at the time, Chair. Yes.
Based on what reasoning?
Based on the reasoning that my leaving the office was not at my instance, at my request. It was the President who wanted me to leave.
And I see that exactly on the issue of whether the President wanted you to leave, which I asked you about earlier on, and you said that indeed he had said that he wanted you to leave.
Yes.
And you said he had said that even before you received the letter from him saying that, or the letter saying there would be an inquiry into your fitness to hold office. I see that in paragraph 10 of this letter dated 10 December 2014 from your attorneys to Mr. Halley, it does say, as the President would want him to. It says, in the circumstances, our client will only consider the option of leaving office as the President would want him to, if he is fully compensated. It seems that this is in some way placed on record that it's the President who wanted you to leave.
That is so, Chair.
And your attorneys were placing on record that you would only accede to that wish on his part if you were fully compensated for the remainder of the period of your contract.
That is so, Chair. And Chair, I can even say that this paragraph was inserted specifically at my insistence because I was part and parcel of drafting this letter.
Yes. You helped draft some of the correspondence
That
from
is-
your attorneys.
That is correct.
Of course, you are an attorney yourself.
Yes, yes.
Yeah.
And that is how I was trained, that whatever discussion we may have had, you follow it up with a written confirmation, which
Yes.
is exactly what we did.
And I'm sure Mr. Pretorius will still take you to any subsequent correspondence. Did Mr. Halley, to whom this letter was addressed, did he ever say, subsequent to this letter, No. What are you people talking about? The president has never said he wants Mr. Nxasana to leave. It is not his position that he wants Mr. Nxasana to leave. Did they deny this part of the letter?
Chair, the letter was addressed to Ms. Bonsu Akene, not Mr. Hali.
It was addressed to the presidency
Yes,
for the attention of Ms. Bonisi Mukene.
yes,
And Ms. Mukene was, as you said, a legal advisor to the president,
yes,
or in the presidency.
yes. She responded, Chair,
Yes.
by way of a letter dated the 12th December 2014, which is annexed at page 192.
Yes, I'm sorry, Mr. Pretorius, I realize that I'm jumping the gun, but maybe we'll deal with that and then you can continue now that.
There is a letter of 12 December 2014.
Yes. Do you want to say anything on it in regard to this particular point, Mr. Nxasana?
Chair, there is no denial in her response, except to say, to refer to this letter, and she says it is not her intention to traverse each and every allegation or averment contained in her correspondence, notwithstanding certain glaring inaccuracies and misstatements of fact. Then he said she reserves her right to do so in the event that it becomes either necessary or appropriate, but she didn't vehemently deny.
Okay, so she said she didn't intend this letter to be a response to each and every thing that had been written in the letter of the 10th of December.
Yes.
And reserved the right
Yes.
to do so later, but pointed out that according to her, there were glaring inaccuracies and misstatements of fact, but didn't go to say which ones those were.
She didn't
Yes.
tabulate them.
Yeah,
And then-
and as far as you know, did anybody, either Ms. Mukene or the president or Mr. Hali, subsequently come back to the issue of this statement that you said, your attorney said the president wanted you to leave? Did they come back to say, actually, was not the case?
It wasn't the case, Chair, except for the president's affidavit, which he filed in the High
In the
Court,
High
and,
Court, yeah.
and subsequently in the Constitutional Court,
Yes.
where he maintained that I made a request, but specifically dealing with this letter, no.
Yes.
I cannot recall where he specifically disputed the contents of this letter. That's why this letter, even in the High Court and in the Constitutional Court, the court found that my version based on this letter
Yeah.
was the most plausible one.
Thank you. I'm sorry, I interrupted.
Just to place this correspondence in its context, you've told the chair that you had discussions with the president about your holding office as NDPP.
Yes, Chair.
Did some of these discussions take place before the 4th of July 2014? The
That is-
notice of the inquiry?
That
or
is
the
correct,
Notice of the intention to consider suspension?
That is correct, Chair.
And you've told the chair that at these meetings, the president expressed a view that you should leave office. Is that correct?
Yes, Chair.
And you've also told the chair that your response was there's no need to do so because there's a campaign and he's being fed with misinformation about you.
That
Is
is
that correct?
Yes.
The subsequent events show that during July, the president acted on what you tell the chair had been his intimation earlier in regard to the termination of your services in whatever manner.
Yes, by his letter,
Right.
dated the 4th of July.
Was there
2014.
ever any occasion on which the termination of services or the termination of your holding of office was at your instance?
Not at any stage, Chair.
Did you ever come to the conclusion that despite your attempts to persuade the President to abandon this idea that you should leave office, which you say you did, there was no point in continuing that avenue because he seemed unwilling to change his mind? Did you ever come to that realization?
No. To abandon the idea
That you should leave office?
at a particular point, I then agreed to enter into a settlement agreement because they were now willing to pay me the remainder of my contract.
Yes, but at whose instance would that termination have been? Yours or the
No,
President's?
it was the President's instance.
That letter of the 10th of December that we talked about a little earlier, referred to the settlement agreement that came from, paragraph 2. Following our discussions of the 8th instant and the subsequent instructions from client regarding the proposed settlement, the proposed settlement that your attorney is talking about there, did it come to them in written form? Was there a letter that came from the presidency saying, here is our settlement proposal? Or is he talking about the discussions at the meeting of the 8th?
Chair, I must have perhaps misplaced that letter. There was, at that meeting, Ms. McKenney produced a document, which was a settlement proposal, proposing a settlement amount of about 6 million rand and some sorts.
Yes.
I remember we had that letter. But the problem, Chair, is that when the matter went for litigation, and I wanted to respond to all these issues, when the President said that I had made a request, my files at my attorney's offices had disappeared. That was a strange thing that happened. And fortunately, I had to rely on, because I used to insist that whatever that they send out, they must send
Give you a copy.
the copies. Then I had put the copies aside. I managed to reconstruct the evidence which enabled me to respond adequately to the President's allegations that I made a request.
You see, Mr. Pretorius asked you some questions and you answered in relation to whether the settlement was in terms of the Npa Act.
Yes, Chair.
Now, if there had been a letter that preceded, that came with the settlement agreement, I would have loved to see that, because there is this issue of whether or not you made a request to the President. And here, in this letter of the 10th, it's made quite clear that as far as you and your attorney are concerned, what you are looking at is not something in terms of the Npa Act.
Yes.
But the NP, what they may have written maybe might have, if what they were looking at was in terms of the Act, it probably would have been in terms of Section 12.8, which necessarily requires a request from your side.
That is the...
And if what they had sent to you or your attorney was a letter which contemplated that their understanding was that the two parties were engaged in a process that requires your request, then the fact that in this letter, you and your attorney are saying, look, what we are talking about is something that is not in terms of the Act, it might make it quite clear that you definitely rejected any concept of a request that you may have made, and it would be important to look at their reaction to that. You can't remember whether the letter that may have come from them with the settlement agreement, if it was a letter, made any reference to the request.
No, Chair, it didn't talk about the request. I remember it vividly. It was a settlement proposal that I relinquish my position and I'll be paid this so much money.
Yes.
That was it. Then we rejected it outright by this letter of the 10th.
Yes.
Yeah.
Did it refer to the Act itself? It might not have referred expressly to the request, but it did refer to Section 12.8 by any chance, if you are able to remember?
Chair, I'm not.
You can't
able
remember?
No, I'm not able to remember.
Okay, no, that's fine.
Contents of the letter.
Okay, that's fine. Thank you, Mr. Pretorius.
Yes, the situation is clarified a little further in the next letter of the 12th of December 2014 at page 192. If you would go there. The intervening letters are just monetary calculations. I'm not sure that those are relevant for present purposes. If we could go to that letter addressed to you by Advocate Bonisiwe Makeni, legal advisor to the President, to Mabunda Incorporated. It reads, I refer to your correspondence dated 10 December 2014, addressed to the Presidency, and respond thereto as follows. 1. It is not my intention to traverse each and every allegation or averment contained in your correspondence, notwithstanding certain glaring inaccuracies and misstatements of fact. I reserve the right to do so in the event that it becomes either necessary or appropriate. Then there's an interesting comment which follows. 2, whilst any negotiated settlement pertaining to your client's employment as NDPP ought properly to be had with the Minister of Justice and Correctional Services, the President assumed this role, mindful as he was of certain reservations which had been expressed regarding the Minister. That statement is fairly clear that what is now being said is that a negotiated settlement is the job of the Minister.
Yes.
Correct? But we know that Section 12.8 is not the function of the Minister, but of the President.
Yes.
So this seems to be an acknowledgement of the fact that if there is to be a negotiated settlement, it should not be then in terms of Section 12.8, but simply a negotiated settlement.
That is so. That was my view, Chair.
And that you had pointed out in your letter of 10 December.
That is so, Chair.
And so on this basis, it appears what is said in paragraph 3, well, perhaps I first should go to the last paragraph in paragraph 2. Notwithstanding such intervention, the President is not at liberty to depart from accepted prescripts which regulate government conduct. Paragraph 3, what now appears apparent is that the parties are incapable of resolving the matter alone, and I must therefore revert to the initial suggestion of making use of the services of an independent mediator in order to find a settlement to the matter. Do you see that?
Yes, I see it.
Then a request is made of you. Then on the 15th of January...
I'm sorry, before that, Mr. Pretorius, if you look at the last sentence of paragraph 2, Mr. Nxasana, of
Yeah.
the letter of 12 December 2014 from Advocate Bonisiwe Mokene, it says that the president is not at liberty to depart from accepted prescripts which regulate government conduct. You see that?
Yes, I say that, Chair.
Within the context, it seems to be saying that they are taking the view that whatever is done must be in terms of the Npa Act. Was that your understanding as well? Is that your understanding of what they are saying?
That was her argument, Chair.
Yes, but then the following paragraph, or the following two, or the last paragraph, or the following two paragraphs, they then talk about going to mediation to settle the matter. Does the National Prosecuting Authority Act make provision for mediations in such a case?
No, Chair.
So to the extent that they proposed mediation, they themselves were proposing something that was outside of the Act.
Yes.
Yes. Okay, thank you.
Well, as the Chair has pointed out, you are an attorney,
Yes.
and you obviously, and as you have said to the Chair, were aware of all the relevant provisions governing any termination or ending of your services as NDPP.
Yes, Chair.
And you were careful to have regard to those when drafting or acceding to correspondence drafted on your behalf.
That is so, Chair.
Perhaps you can help us then, because paragraph 2 and paragraph 3 seem to be a little confusing, at least at first glance, because on the one hand, they're saying a negotiated settlement must involve the Minister of Justice and Correctional Services and not the President.
Yes.
And on the other hand, they're saying that the President can only act in terms of accepted prescripts, whatever those might be. We know that Section 12.8 involves the President directly. It is he that must exercise his discretion in terms of Section 12.8 at your request,
That is
or at the request of the NDPP wishing to resign. Nevertheless, there's a statement here that a negotiated settlement pertaining to your employment should not be at the hands of the President, but at the hands of the Minister. Can you explain what is going on here?
Chair, I understood this paragraph to be saying that whilst it was the responsibility of the minister to deal with the issue of my issue, the president assumed unto himself to deal with this issue. It was confusing to me, I must admit, but I thought she was just saying that it was the responsibility of the minister to deal with this, not the president. And the minister must, after dealing with any issues, then the minister as the member of parliament responsible for, who exercise final responsibility over NPA, should then communicate it to the president and for the president to take a decision.
Yes. Because we know that Section 12 of the Npa Act, you may recall, says that no termination of service may take place other than in accordance with the prescripts of Section 12.
That is so.
Had you expressed any reservations about the minister to the president? I asked that because they refer to something along those lines. It seems that what they are saying is the president was aware that you had expressed certain reservations about the Minister of Justice, I don't know in regard to what, but you had expressed certain reservations, and that's why he therefore played this role himself, which they seem to suggest ought to have been played by the Minister of Justice.
Yes, Chair.
You had?
Yes, I had, Chair.
Yes.
Chair, I had verbally expressed my dissatisfaction at the manner in which the Minister of Justice handled my matter.
That is Minister Masuta.
Firstly, it was Minister Adv.
Yes.
I also am on record. I wrote a letter and expressed my discomfort and dissatisfaction in the manner in which he treated me.
Yes.
Because he is the first person who told me about the fact that he was going to advise the president to institute
An inquiry.
the inquiry. What does not appear in these papers, Chair, just briefly,
Yes.
is that before Minister Adv was removed or reshuffled from this position of Minister of Justice, he called me to a meeting in Pretoria in his office. Present there was himself and the DG, then Ms. Sindani. And at that meeting, he then confronted me with all these allegations of my previous convictions, of my matters that were, the complaints that were laid against me in the KwaZulu-Natal Law Society, and that I did not declare all of those, which was not correct. And I told him at that meeting that I know the campaign, and that was the first person I told, that the campaign, I'm aware of the campaign waged by Advocate Jiba and Mrwebi against me. I tried to explain myself. He dismissed me by saying that that was a figment of my own imagination. And then he suggested to me that I must resign because of all of this. In fact, his trump card was that, but now you don't have the security clearance certificate. And I found it odd because I'm the one who had applied for the security clearance certificate, and I had not been told by the state security agents that my security clearance has been declined, and which I subsequently learned it was not even the case. And I refused.
You mean that it had been declined? You say it was not the case?
It was not the case. It was never declined. But that is what Minister Adv told me. It was not the case. That was the initial push. They tried to push me. Then I refused. And then he said to me I must resign, and they agreed with the DG Sindani. I told them that I was not going to do that. Then he said to me then that the president will have to appoint the commission of inquiry. Then I left the meeting. And the following day I addressed the letter to him.
I'm sorry, before the following day, are you able to indicate round about when this was? You know, there was an election in 2014.
Chair.
And I think that may be when he might have ceased to be Minister of Justice.
I remember
and then
that.
Mr. Masuta came in.
I remember he was going, was it in December or January 2014? December 2013 or
Well,
January?
I think he wasn't Minister of Justice after the election of 2014.
Yes.
So if you had a meeting with him while he was Minister of Justice, it could only have been before the election.
Before the elections?
Or at least before the inauguration of the president, because ministers continue to operate as ministers even after the election, as long as the president has not been inaugurated yet.
Chair, I know that he was coming from the parliament was sitting.
The election would have been around May, I think, more or less, 2014.
2014. But I know that he was coming from Cape Town.
Yeah.
And immediately after our meeting, I think immediately thereafter, he was then removed from that position and he went to the presidency.
So if his departure from the Ministry of Justice was after the election, then your meeting with him must have been close to the election or between the election and the inauguration.
Chair, I do have the date at home because
Okay.
I have the copy of that
Yes.
letter that I wrote to him confirming what had happened on that day.
Okay, no, I think then what can happen is that later on you could do a supplementary affidavit and or statement and attach the letter and indicate that you are able to say what date the meeting took place.
Yes,
But you were saying that the
Yes.
following day you wrote a letter.
yes, Chair.
Yes.
Confirming what transpired the
Yes.
previous night. Yes, and I did not get any response.
And what did you say, the gist of what you said in your letter, what you recorded or what you said, what did you convey to him?
I confirmed that he called me to a meeting and that this is what had happened at the meeting.
As you have testified to
As
it now.
I have testified, and I called I called EXCO, and I explained to EXCO what had happened.
Yes,
It's
okay.
It's minuted, it's there
Yes.
at Npa.
Okay, thank you.
And then I think the comments, the remarks that she might be referring to here, yes, I also made remarks, verbal remarks about Minister Masuta, I think at the meeting of the 8th
Yes, at the
Yes.
meeting of the 8th of December.
of December.
Uh-huh.
Chair, when you'd understand that after I had had that interaction with Minister Khatebe, you'd understand my attitude. Then when it was announced that we were having a new minister, I said it's a relief. Then I'm having a new minister with fresh ideas and he'll be able to not to play all this NPA politics as I perceived Minister Khatebe was doing. But strangely, Minister Masuta, I then saw him on the news talking about the issue, my issue, without even having had the decency of meeting me and even finding out from me or getting my version of the events. And he was already making statements about me in the meeting. And I told him himself at the meeting that I had with him at the hotel.
The first meeting you had with him,
With Masuta. I
with
remember
Minister Masuta.
Masuta, we had a meeting, there was an evening meeting also that I had with him at the Sheraton Hotel, and I told him that I'm very concerned in the manner in which he was behaving, because I got the impression, I told him that he was taking sides, because, and then he assured me that he didn't know either Jiba or myself. That is what he was, but I think in this letter, that is the remark that Ms. Bonisio McKenna is referring to, because I said I had some reservations about the partiality of the Minister Masuta in this whole matter.
But this letter is dated 12 December 2014, or is that the word? Yeah, 2014. Yes. And it responds to a letter that recorded what had transpired at the meeting of the 8th of December.
That is so.
So my question is, prior to the 8th of December, prior to that meeting, had you conveyed to the president or anybody acting on the president your reservations about Minister Masuta?
So my response, Chair, my response is that at the meeting of the 8th of December, before they responded on the 12th, I must have conveyed my reservations about Minister Masuta at that meeting, or even before that.
Yes, but you see, the president had interacted with you.
Yes.
prior to the 8th of December, if I understand the position correctly.
That is correct. Yeah.
And Ms. Mogene is trying to justify why the president performed functions that she says should have been performed by the Minister of Justice, namely negotiating with you, as I understand the position.
Yes.
So what he may have done prior to the 8th of December can be used to justify him handling this matter himself if he only got to know about your reservations on the 8th or after. So my question is whether you had conveyed to the president or through to people representing him much earlier that you had reservations about Minister Masuta.
That is the position, Chair. To the president and to Mr. Hali as well.
You had?
Yes, Chair.
Okay, no, thank you.
Chair, it's 4:10. Mr. Nxasana is due to fly, subject to what you say, at 8:05. We could attempt to finish by 6 o'clock, when I think Mr. Nxasana should leave at the latest. But I can't guarantee we'll finish in that time at the rapid pace at which we're going. Even that might not, although once we finish the timeline, we will go quite quickly.
Well, we certainly can go up to 5. Whether we can go beyond that, maybe we can deal with that close to 5 or around 5 o'clock. So let's see how it goes.
Let's see how far we can get by 5 o'clock and see then what happens. Okay. It's probably necessary to place it on record because you did mention an issue concerning the security clearance certificate. That is dealt with on page 189 in the letter of your attorneys to the presidency of 10 December 2014.
That is correct.
And if I can just read paragraphs 11 to 13 onto the record and you can confirm whether that's correct or not. We confirm, says Mr. Mabunda on your behalf, that the President advised us that the Minister of the State Security Agency, the Minister, has confirmed that he has upheld the NDPP's appeal against the refusal to grant him the security clearance, and he has already issued it, but he is waiting to hand it over to the NDPP upon finalization of the settlement between the parties. Paragraph 12, while we do appreciate and welcome the Minister's decision to uphold the NDPP's appeal, it is our respectful view that the granting of the security clearance certificate to the NDPP is and or should not be a condition for any proposed settlement. 13, we are accordingly bringing it to your attention that we are dispatching a letter to the Minister to release the security clearance certificate to the NDPP. Now, I don't think it's necessary to go into whether it's a valid reason for withholding the certificate, that there is no settlement between the parties. I think that's the answer to that question is fairly obvious, but are the facts here correct?
The facts are correct, Chair.
All right, then let's go then to the letter of the 12th of December 2014, which is the Presidency's response to the letter we've just dealt with. That's the letter of the 10th of December addressed by your attorneys to the Presidency. The first paragraph, and it's signed by...
I thought we have dealt with that letter. I think I remember you reading the first paragraph, and we have certainly dealt with the paragraph that says it is not my intention to traverse each and every allegation. And then we dealt with the one that says, whilst any negotiated settlement pertaining to our client's employment. I think we have dealt with the whole of it.
My recollection is we dealt with another letter, Chair, but...
No, it was this one. There may be one or other point that you want to make, but I think you remember in regard to paragraph, the last two paragraphs, we looked at the last sentence of paragraph 2.
Yes, we did.
Yes, and
I want to get to paragraph 3, however.
Yeah, okay.
Paragraph 3 reads, "What now appears apparent is that the parties are incapable of resolving the matter alone, and I must therefore revert to the initial suggestion of making the use of services of an independent mediator." I think that's where we left the letter.
Yes.
Correct. And then on the 15th of January, your attorneys once more enter the fray.
Yes.
And firstly, you acknowledge receipt of a letter dated 9 December 2014 and received by our office on the 9th of January 2015. Now that may be a mistake. It may be referring to the letter of 10 December, or it may be referring to a letter that we could not find, and you've mentioned that's the letter setting out a settlement proposal. Can you help us there? Do you know of any letter of 9 December 2014, as opposed to the letter of 10 December 2014?
I cannot recall, Chair.
All right. Well, we don't have any letter of 9 December, and it may be that they're actually referring to your letter of 10 December.
Chair, I think there must have been a letter of the 9th December, because the letter that of the 10th of December is a letter from ourselves.
Yes, that may have been the one that brought the settlement proposal.
Perhaps, Chair. But it's the letter that was coming from them.
All right. Well, perhaps in the fullness of time we can find that letter. But let's go to paragraph 2. We place on record that we have been liaising and corresponding with Mr. Michael Hulley before you were introduced to us as the legal advisor to the President. 3, at all material times, Mr. Hulley has always represented to us, which we accept, that he was the legal representative of the President. It was at his instance and request that the formal engagement which bears reference was initiated. The formal engagement referred to there, do you know what it is? Is that perhaps a mediation?
I think the formal engagements that we had between the engagements that we had on the 8th,
All right.
8th of December, when Ms. McCann was available.
Right. Paragraph 4 reads, "We are noting the tone of your letter, which is somewhat unsavory and unreconciliatory. We would like to bring to your attention that our communication to Mr. Hulley, dated the 3rd of November 2014, is still of relevance in this case and equally remains on record. We enclose here with a copy of the said letter received and read by Mr. Hulley for the ease of your reference." And then paragraph 5, "You will note from the said letter that our client had always been and still remains amenable to the proposed mediation. It is, however, apposite that you attend to the proposed terms of reference for the mediation for consideration and acceptance by our client." We can leave the rest. Paragraph 6 on page 194, "We must record that our client is amenable to a proposed independent mediation and not a confidential one you seem to be proposing." Then paragraph 7, "We further wish to record that our client has at no stage initiated the discussions regarding settlement proposal. In terms of paragraph 2 of your letter, you seem to be creating an impression that the Minister and not the President should have been the one liaising with our client regarding the issue in question. We venture not to express an opinion in this regard. We are equally unaware of any formal meeting between the Minister and our client, trusting you find the above in order." That is the letter you sent then to the Presidency,
That is correct.
where you placed yourself clearly on record. Now, there was a space of time between the 10th of December and the 15th of January 2015.
Yes.
It seems from the letter of 15 January 2015 that there was some hiatus in correspondence in that period.
That is so.
During that period, did you ever meet personally with the President? Oh, well, let me first ask, is there any other correspondent of which you might be aware that would alter what is clearly set out in the letter, your letter of 10 December 2014 and 15 January 2015?
No,
Did that
Chair.
ever change in the interim period?
No, Chair, there was
Right.
nothing.
Were there any meetings between you and the President in that intervening period?
Although I cannot recall, but I would say, I cannot recall having a meeting with him. I cannot.
In any meeting with the President or the President's legal advisor at any stage, or even with Mr. Hulley for that matter, did you ever abandon or qualify the position that you were not a fit and proper person, or that you were indeed a fit and proper person to continue holding office?
At no stage, Chair, did I abandon my view.
Did you ever communicate to anybody in the presidency, the President, or representing the presidency, that you wished at your instance to vacate office?
No, Chair.
You did, however, say that if you were fully compensated for the remainder of your term of office, you would leave.
Yes, Chair, because they were pushing me to leave, and I could see they had taken a decision.
Had you left, at whose instance would your departure have been?
Had I left?
Yes. Had you, well, you did leave eventually.
Yes, I did.
But at this stage in December, because we're going to deal with what
Oh,
happened
okay.
afterwards now.
I would have left at the instance of the President.
It's going to be important that you try and remember whether in December or January you did have a meeting personally with the President, because in the Corruption Watch CASAC matter, I think there is an affidavit in his answering affidavit, or one of the affidavits by the President. He says it was between the end of December and the beginning of 2015. He says between the end of December and the beginning of 2015, there were discussions. And he says it was during maybe one of those discussions that you made the request. Now we know that there was a meeting which involved both of you and other people on the 8th of December 2014. And we know that on the 10th of December, your attorneys wrote a letter which you drafted yourself to record what had been discussed at the meeting of the 8th of December.
Yes.
We know that Ms. Mukene wrote a letter on the 12th of December, responding to the letter of the 10th of December, if I recall correctly. But and I think then there was another letter, if I'm not mistaken, from your attorneys, or maybe your attorneys then wrote in January.
15.
Now, so therefore, it seems that the request that the former president says you made to him, if ever it was made between the end of December and the beginning of January. So it will be important for you to remember, not necessarily now if you can't remember, if there are other documents that might assist you at home to remember whether you did have such a meeting, to be able to prepare a supplementary affidavit that deals with whether you had any meeting or telephone discussion or any discussion at all with him during that time.
I have to add, the
Yes.
affidavit you're referring to is now in the bundle.
Oh, it is in the bundle, okay.
Is now in the bundle, and he Mr. Nxasana has been given a copy to consider,
Yes.
and I had
Yes.
intended to ask him about it.
Yes,
time permitting.
okay. So if you want to respond to what I've just said, you may do so. If you want to go and check certain documents and try and remember, that's fine.
Chair, I was going to respond in this way. My response is that in as much as I cannot recall whether we had any interaction, be it a meeting or telephone discussion or otherwise. But the fact, I think what Mr. Pretorius wants to know is that did at any stage make a request? And my answer is a big no. I've never made a request.
Well, no, that I understand that, but you see, if indeed there was a meeting between yourself and the former president during that time, that might give a certain flavor maybe to the issue. But if the position is there was no meeting at all or any discussion at all, it might give a different flavor. You understand what I mean? So you might say, yes, well, whatever meeting I had with him, I did have a meeting, what I do know is that I never made such a request. That's fine. But he says there were discussions during that time, and if the position is there were no discussions, that might be important as well. You understand that?
I understand, Chair.
Yes, okay, all right. Thank you.
Of course, the possible scenario that there was such a meeting at which resignation was requested in terms of Section 8.2 would beg the question of why negotiations fell through at that stage. But that's a matter that we can deal with in submissions, Chair. But if we may then go to paragraph 2 and 3 of page 195, which is a letter of the 23rd of January 2015.
I'm sorry, Mr. Pretorius. I wanted to say something about something at paragraph 1, at page 194. Mr. Nxasana, I see that in this letter of 15 January, paragraph 7 thereof says, we further wish to record that our client has at no stage initiated the discussions regarding settlement proposals. This seems to suggest that the settlement proposals or settlement negotiations that were taking place were initiated by the presidency and not by yourselves. Is that right?
That is correct, Chair.
Yes, you never initiated any negotiations.
I never initiated any negotiation, Chair.
Yes, okay, thank you. And as far as you know, this was never denied in any correspondence that they were the ones who initiated, or that you never initiated the settlement discussions?
No, because in the letter of the 23rd of January, the next page,
Yes,
Advocate Bonsiwe Makene doesn't even refer, she doesn't dispute that. Safe to say that there's been insufficient progress in resolving
Yes.
the matter. Yeah.
yes,
And paragraph 2 is very important because it talks about there's been insufficient, she says it appears apparent that insufficient progress has been made in respect of resolving your client's current status as National Director of Public Prosecutions. That is why I was saying the discussions were around everything about, not just about the settlement proposal in terms of the money. It was about everything. Whether
Yes. What did you understand that part to be, resolving your client's current status as National Director of Public Prosecutions? What did you understand them to be talking about in regard to that?
I understood it to mean that there was insufficient progress in resolving the matter whether or not I remain in office or that I am leaving.
Okay, thank you.
Well, let's deal with paragraphs 2 and... My apologies. Let's deal with paragraphs 2 and 3 of the letter. It says, and paragraph 1, in fact. Paragraph 1 reads, I, and that's the legal advisor to the President, refer to your recent correspondence in respect of this matter and reserve our rights to deal with certain aspects contained therein. Notably, there's no reference to any meeting that has taken place in this period.
That is correct, Chair.
Let alone a meeting at which you request to resign.
That is correct, Chair.
Paragraph 2 reads, it appears apparent that insufficient progress has been made in respect of resolving your client's current status as National Director of Public Prosecutions. You've answered the Chair's question in that regard.
Yes.
Paragraph 3, I must accordingly advise that after consideration of the matter, President Zuma has taken a decision to proceed with the inquiry into Mr. Nxasana's fitness to hold office. And then over the page on the 26th of January, your attorneys address a letter to the Presidency saying, we note the President's intention to proceed with the inquiry into our client's fitness to hold office. Kindly advise us when we can expect to receive the terms of reference for the inquiry. If we can then go back, that's pretty self-explanatory. Is there any comment that you wish to make?
I think, Chair, it explains this exchange of correspondence. It clearly explains that there was no progress reached, and my attitude, and the attitude was that the President then decided to proceed with the inquiry, and I said, bring it on. That's exactly what I said.
Yes.
Had there been a request for you to resign made directly to the President in terms of Section 12.8 of the Npa Act, and the only question then remaining was the financial consequences of the President accepting your request to resign, would that have been progress in the context of what happened in progress in the sense of getting closer to finalization? Not progress in respect of being satisfactory to you.
Surely, if I had made a request, Chair, in fact, if I had made a request to resign, it doesn't make any sense that I will make a request to resign and at the same time expect to be paid the full amount of the contract. I mean, it doesn't take a rocket scientist. That is nonsensical. It doesn't make sense at all.
You've made that point, yes.
Yes.
All right.
Is the point you are making this, that if you yourself made the decision that you want to request the President to allow you to leave,
Yes.
and then it wouldn't be expected that you, having decided that you want to be allowed to leave, that you would then want to be paid for the full remainder of the full contract, the full remaining period of your contract. What's consistent with that demand that you be paid for the full remaining period of your contract is if the other side wanted you to leave against your will,
Against my will.
and then you say,
Pay me. for
since I'm not the one who wants to leave, you are the ones who want me to leave, then pay me, because I have been prepared to stay on up to the end of my period of contract.
That is the position, Chair.
And the point you're making is that the fact that they acceded to that, you are saying means that, or shows that it was the other side that wanted you to leave, and not you.
That is so, Chair.
That's the point you are making.
That is the point I'm making, Chair.
Okay.
If we could go back, Mr. Nxasana, to the timeline, we have dealt with all the items up to item 14. The further items are dealt with in your evidence, and we will deal with them briefly. But it appears that on the 5th of February 2015, you were informed that Advocate Kasim, assisted by Advocate Nkosi Thomas and SKD Madlala, would chair the inquiry.
That is correct.
That's Mdladla, not Madlala, Mr. Pretorius.
What should it be?
Mdladla, not Madlala.
Oh,
It's Mdladla.
Then item 16 is a reference to publication in the Government Gazette of the terms of reference in the inquiry. And then item 17, March 2015, the NPA workshop at Emperor's Palace, at which you were apparently told by the minister that the former president would attend to your advice or requests in relation to Advocates Jiba and others.
That is correct, Chair.
You then filed submissions on behalf of the President and the Minister were filed on the 4th of May. You also filed submissions, did you?
I did not
Or
file
you
the
prepared submissions?
I prepared the submissions, but before filing them, we reached settlement, and I ended up not filing the.
And that settlement was concluded in May 2015, signed by yourself on the 9th of May, and signed by the former President on the 14th of May, together with the Minister.
I think signed by the Minister on behalf of the President on the 14th of May, if I'm not mistaken.
Is that how it occurred?
That, if I'm not mistaken, yes.
All right, well, we can have a look at that. We don't have the settlement agreement attached. But is there anything significant in the fact that the settlement agreement was signed by you first and only later on behalf of the former president?
That is correct, because if you look at the settlement agreement, I signed it at Umhlanga. It's dated at Umhlanga in Durban, at the offices of Mr. Hali.
I see. Who prepared the document?
I suppose it was Mr. Hali.
But
because
not you?
Not me. In
Okay.
fact, just to clarify, there was he sent me, I think it also, it is then the bundle of documents that came up before the Court, I think, and the High Court and the Court, that he initially sent me a proposed settlement of a certain amount of money, and then I rejected it. Then he sent me another settlement with without any amount and asked me to insert the amount. Then I calculated the salary that I was earning at the time and multiplied it by the number of months that were remaining.
Mr. Pretorius, I think that I will be agreeable to going beyond 5 o'clock in order to try and help us to finish. But I think we must then in that event take an adjournment now, because I had the meeting planned for 5 o'clock and need to change that. But in any event, it might be good to have a break now. Is that fine? So in other words, from my side, you mentioned 6 o'clock. We could go up to 6 o'clock if we don't finish before that from my side. You are fine with that? How long do you think we might still be? Or maybe you must tell me that when we come back from the break. Mr. Nxasana.
We may finish because there are sections that we can summarize. And we've dealt already with the contents of the Constitutional Court judgment and the confirmation by Mr. Nxasana of what was said there.
Yeah, no, that's fine, but we'll take a break now. And when I come back, we continue. If we finish before 6 o'clock, all the better. I take it that's fine with you, Mr. Nxasana?
It's fine with me, Chair.
Yeah. Okay, let's take a 10 minutes break. We'll resume at 10 to 5, or should we take 15 minutes?
I'm in your hands, Chair. Perhaps 15.
Yeah, maybe 15. Okay, we'll resume at 5 to 5.
Thank you, Chair.
We adjourn.
All rise.